thank you very much. I would say, in listening to the charges from the judge, who's, as you know, very conflicted and corrupt, because of the confliction, very, very corrupt. Mother Teresa could not beat these charges.
Jury has been sent to deliberate. Just wait till you hear what Judge Merchan's instructions to the jury were. You might not even be shocked. You might not even be mind blown, but I tell you this, it's something that nobody in the history of the criminal justice system could have ever foresaw happening in this day and age. The Trump trial in New York City, the sham trial that every single legal scholar, legal expert, legal specialist, legal law professor of any worth has noted there's no merit here, there's no grounds here, has ended. It's over. Closing arguments are over, which, by the way, if you missed my video yesterday, the prosecution went over 5 hours and basically conducted a filibuster. Meanwhile, the defense attorney, Todd Blanche, he was done in just a couple of hours. Efficient, to the point, direct, conclusive, evidentiary, and substantive. Those are superlatives that have been hurled upon Todd Blanche from every single legal scholar and legal expert in the country. Here is the complete breakdown of how unprecedented Merchan's novel theory, complete out of left field theory of criminal liability is. Now, normally in a criminal trial, the constitutional requirement is that a jury reaches a unanimous verdict on guilt or innocence. Unanimity requires that all the jurors believe the burden of proof. Remember, the burden of proof is not on the defense, it's on the prosecution. It has to be beyond a reasonable doubt, and has been satisfied on every element of the alleged crime, which we still have no clue what the alleged crime are, what the 34 counts entail. There is no crime, there is no victim, there's nothing to pin Trump on. Implicit in this scheme is that there's also unanimity on what the underlying crime is. You can't have one juror believing the burden of proof was met by one crime and another juror believing the burden of proof was reached from another, but not the first crime. And because both jurors believe the defendant was guilty for quote unquote something, that fact alone should drive a guilty verdict. That would be an absolute violation of due process. It implicates double jeopardy issues, and it completely destroys the high evidentiary standard needed to prove guilt in a criminal trial. But apparently for Merchan, none of that matters. If juror one, so this is what this means. If juror one believes the people did not meet its burden of proof for the FEC violation, but did on some nebulous tax law evasion violation, while juror two believes the opposite, the fact that they both were in consensus on a guilty verdict, I can't believe I'm saying this, but according to Merchan, is actually sufficient for a guilty verdict. Here's what I mean. Merchan says if there was a conspiracy to affect the outcome of an election, jury can consider whether the defendant violated the following laws. Number one, Federal Employees Compensation Act, FECA. Number two, falsification of business records. Or number three, tax laws. I mean, this is like the broadest definition of a crime in history. Merchan is literally throwing the entire book at the jury. What authority does he have as a state court judge from a mediocre law school to opine on something as nuanced as federal election law? He's the fake Don Juan Merchan. It's so egregious. It's so rigged. It's not even funny, Des Nation. It's so intricate, FEC law, and complex that the FEC has exclusive jurisdiction and ordinarily preempts other courts from all federal election law related issues. So this is beyond utterly outrageous. Merchan is deliberately, this is an actual concerted, premeditated, self-interest based proceeding. Merchan is deliberately lowering the threshold for what Bragg needs to prove in order to more easily reach a guilty verdict. It's the coup de grace for Merchan. That means it could be a 4-4-4 split. They don't have to unanimously agree on what the actual crime is, but they do have to unanimously agree that is either guilty or innocent. It's nuts. Paul Ingracia, who was reporting from the actual courtroom, said this. He said Mershon was speaking when he was giving jury instructions to the jury. Mershon was speaking in very quiet voice, mumbling at times, speed reading through the jury instructions. Very difficult to hear. Why were you doing that, Judge Mershon? Why were you acting so coy? Notably, though, Paul Ingracia says, his voice gets slightly louder when he talks about a, quote, guilty, end quote, verdict. And his voice quiets to a near whisper when he says, quote, not guilty, end quote. His enunciation, his tone, cadence, volume is left much to be desired. And I think, in my humble opinion, shows a clear-cut evidence of bias, 1 billion %. What do you guys think? I want to hear what you guys think in the comments. I can't wait to read your comments on this. So what this means is, number one, 4 jurors could agree on the first crime. Let's say it's falsifying records. 4 could also disagree with that, but agree on the second quote-unquote crime, tax violations. And yet another third 4 could agree on federal election violations. And Judge Mershon would still count that as a unanimous guilty verdict from 12-member jury. This is, you can't even say rigged. You can't even say the fix. It is so absurd with a capital A.
Well, let me ask you about the 3 choices. And one thing in particular that this judge said that these jurors could do. He just delivered what is being called really the pinnacle of all of this. He said that there is no need to agree on what has occurred. They can disagree on what the crime was among the 3 choices. Thus, this means that they could split 4-4-4 and the judge would still treat them unanimously. What does that mean?
Yeah. Well, it's really outrageous because in a normal criminal case, every statutory crime has what we call elements of the offense. Like in a bank robbery case, it's, you have to rob, it's got to be a financial institution, you have to show intent. Those are the things the jury has to agree on unanimously that they were proved beyond a reasonable doubt. Here, what we're doing is taking the element that actually makes this a felony, because remember, falsification of records is normally a misdemeanor in New York. What makes it a felony is that you're concealing or committing another crime. And here the judge is telling them they don't have to agree about what the other crime is under circumstances where that not only is what makes this a felony, what makes it a 4-year potential prison penalty rather than a year or less, but it's also what gets us into the courtroom, because if this had been a misdemeanor, the time to bring this case would have lapsed in 2019. So the only reason they're still able to bring this case is because it's a felony, allegedly, and yet now the judge is saying, you don't have to agree on what the felony is.
I want to read what Jonathan Turley said on X. Jonathan Turley, who is a Democrat, so this is not biased, and he is a, worldwide renowned, credible legal scholar, legal professor, and legal expert, says Mershon delivered the coup de grace instruction. He said there's no need to agree on what occurred. What? They can disagree on what the crime was among the 3 choices. Thus, this means that they could split 4-4-4, and he will still treat them as unanimous. So just really quickly before we go, what does this mean? How long will deliberations go? What's going on? So jurors can communicate with the court through notes that ask the judge, for instance, for legal guidance or to have particular excerpts of testimony read back to them. But without knowing what jurors are saying to each other, it's hard to read into too much into any of the meaning of the note. It's anybody's guess how long the jury will deliberate for. There's no time limit either. The jury must evaluate 34 counts of falsified business records, so that could take some time, and a verdict might not come by the end of a week. Standard court day runs from 9:30 to 4:30 p.m. with a break for lunch. Judges sometimes extend the hours if jurors wish. In this case, I'm sure Mershon, who's already decided that deliberations will proceed on Wednesday, but there is no limit on how many days deliberations can continue. So you got to stay tuned. I'm going to keep you abreast of everything that's happening. This is your one-stop shop. You don't need to go anywhere. Make sure you follow. Make sure you subscribe. Subscribe to our free newsletter. All the links are in the pinned comment, show notes, and description. This could be historic. I can't wait to hear what your thoughts are. Let me know in the comments down below. I'm looking so forward to reading your comments. Obviously, it's impossible for me to respond to all of them, so consider becoming a member because you get not only that perk of first response, first dibs, you also get a ton of other perks. We have our members-only Discord, which is thriving with engagement of like-minded people. You can hang out, have fun, talk. It's amazing. And plus, you're supporting our channel. All proceeds go back into the channel. It only costs a cup of coffee a month. You spend more than that in 30 seconds. All those links will be in the pinned comment, show notes, and description. Check out these videos coming up on the screen right now. Follow and subscribe. And as always, God bless you, and may God bless America. I'll see you soon.